replacement for our host, Jack Potter, who had surgery. His voice isn't quite up to par, so please forgive me if I have a script that I screw up. Okay, so first of all, we wanted to, on behalf of Red Bear Healing Home Society, welcome and thank you for attending our second Truth and Reconciliation Cafe. My name is Mal, I'm on the board of directors, and we're especially glad to have live stream participants tonight as well. Thanks to everybody who's joining remotely. And this recording will remain available online after the event as well for those who are unable to join us tonight. Okay, we're happy to be back at Dalhousie University in the Student Union Building where we held our first cafe event located on unceded, unsurrendered Mi'kmaq territory. Red Bear Healing Home started about 10 years ago. It's a non-profit to provide free voicemail to people who are experiencing poverty. I have some of our board members here tonight. And in regards to the Truth and Reconciliation Commission's report and calls to action, we aimed to promote open public education, awareness, and action with the first Truth and Reconciliation Cafe in February. That was aimed at understanding the effects of residential schools by hearing the direct voices and lived experiences of residential school survivors and their families. It was a very powerful experience for everybody. And we collaborated with Nova Scotia Public Interest Research Group, who were generously providing funding for this, so we thank them. And we wanted to thank Lauren Amiot, I'm sure I pronounced that wrong, who is the event manager at the Dalhousie Student Union Building. Okay, finally, we would like to thank our speaker, Professor Naiomi Metallic, fortunate to have her here with us tonight, very generously sharing her time with us to speak about her work on the topic of Indigenous people and Canadian law. Professor Metallic hails from Listowel, Mi'kmaq, the First Nation located in the Gaspe Coast of Quebec, known as the Gaspégoagé district of Mi'kmaq. She's fluent in both English and French, and is becoming fluent in Mi'kmaq, which she has been studying since 2018. Professor Metallic is a graduate of Dal, where she earned her BA and Bachelor of Law degrees, completed her licentiate in law at the University of Ottawa, summa cum laude, before moving on to complete her Master's in Law with Osgoode Hall Law School. After 10 years of practice in Aboriginal law, she decided to make the move to academia and to continue her work through teaching, writing, and speaking about the issues facing Indigenous peoples in Canada and how the law can be a tool for reconciliation and improving the lives of Indigenous peoples. Since 2016, she's been an assistant professor at the Schulich School of Law at Dal, where she also holds the Chancellor's Chair in Aboriginal Law and Policy. And she's working on her PhD through the University of Alberta, and then she wrote, stop.
That was enough.
That's enough. Just a quick thing. So I'd like to introduce Naiomi Metallic, and there will be a short break in between some of the presentations. And there's also, please feel free to ask questions as we go. We're going to try to do an official Q&A, but we're pretty loose. So,
thank you.
Professor Metallic.
Well, thank you very much for inviting me and having me. Wildasi Bekisin Gisko, which means I'm very happy to be with you today. I guess I could say Wildasi Bekisin Walag, which means I'm happy to be with you tonight. Okay. Yeah, so, and I forgot your name, that's terrible.
Me? Oh, Mal.
Mal?
Yeah.
All right. As Mal was saying, yeah, feel free to ask questions since there's only a few of us. Yeah, closer.
No, the light is coming. If you're on right about there, then the light won't be.
Perfect. It's not like on my forehead. Great.
Yeah.
Yeah, so yeah, thanks so much. I'm really happy to come and speak to you tonight about some of my expertise in the area of Aboriginal law. Yeah, and just in case you've heard concept or the terminology Indigenous law and Aboriginal law, just to like tell you the difference, because there is one. Aboriginal law is the stuff we're going to talk about tonight. It's Canadian law as it relates to Indigenous people. So that could be statutory law, or particularly we're going to talk about the Indian Act and the Constitution Act. So Canadian laws as they relate to Indigenous peoples. But there's this whole emerging field around Indigenous law, which are the laws of the Indigenous peoples of Canada. In fact, we're kind of undergoing a revitalization movement right now. And anyway, if you're looking for a third subject to have some of your reconciliation talks about, I highly recommend perhaps looking at that, and I can recommend some speakers. I've been starting to teach some courses in that, and it's an important area to talk about as well, but very happy to talk on this subject. I've got two presentations which collectively are about 20 slides. So I think that'll give us certainly an hour, and I can talk, especially if I get questions. And so my two presentations. Oh.
I got it now.
Oh.
I got it now.
So the two presentations that I have, one is something I developed around 2015 or 2016, and I've updated it since. But it sort of looks at where we are in the current moment with respect to Indigenous peoples in Canada, and I'll talk to this slide in a minute. The idea of it is to, well, actually I'll talk about it right now. These four eras that I have on the screen come from the Royal Commission report on Aboriginal peoples, which was a report produced in 1996. And it's a massive report and has amazing information in it, and I'll speak to some of that later. But the first volume of it explains it gives sort of a historical overview between Indigenous peoples and Canada, and in that sort of sets out sort of four eras. Or tries to classify the relationship in four eras. The first one being the pre-contact worlds, where Indigenous peoples were here, lived on the land, had their own legal systems, had their own laws, cultures, traditions, languages. And then we get the first couple hundred years of contact, wherein we see significant treaty relationships being made between the different European powers that were coming here, or we have primarily, though, treaties with the British. And this is an important era to speak about as well. I've given talks, and there's some people who are just brilliant around this period of time. We often don't talk about it and sort of disregard it, but what's significant about it is that when, Britain and France were sort of warring for what they might say is control over North America, they were still at the same time also engaging with the Indigenous peoples here in such a way as to convey to them that their intention was not to dominate the Indigenous peoples, that the treaties that were signed at this time were not about cession of land, they were simply about coexistence and living together. Some of these treaties were signed as sort of allies, or as to be neutral, in particular Indigenous folks to be neutral in between the wars between Britain and France. This treaty period is, fascinating, and somebody can come and give a really good talk about what were some of the representations that were made to the Indigenous people at the time. There was this big conference in Niagara in 1764, a year after the signing of the Royal Proclamation, and at that conference, 20 different Indigenous nations from like the Mississippi, westward, eastward, all over came, and the whole idea was that there was a representative of the British Crown who spoke to all of these representatives about what the Royal Proclamation meant. It wasn't intended to take Indigenous land. If Indigenous folks wanted to sell land, they could sell it to the Crown, but they would have to agree and consent to it. And also, the British Crown also represented that it wasn't their intent to take over or control the lives of Indigenous peoples, and they use these wampum belts. I don't know if you've heard about wampum belts, but this 2-row wampum belt that sort of signifies almost two ships traveling on the same water together, but not touching each other, not interfering with each other. And that was used as a metaphor to explain that both would coexist in this space, but not one or the other controlling each other. And there have been theorists and legal theorists for quite some time who have argued that that relationship could have had such a significant impact on how we interpret Canadian law today, and still can. But we've often ignored that history. People who make that relationship, they refer to the possibility of it as treaty federalism. And there's some brilliant writing on this. That if we took a treaty federalism approach, we could have a very different relationship in Canada. And often when people today talk about nation to nation, it's along the lines of these sorts of discussions around treaty federalism. It's a fascinating topic, and that's about all I'm going to do on it for now. And then, because a lot of the focus has been on the third era that RCAP touches on in its report, it calls it the era of domination and assimilation, that happened sometime in the mid-18th century, and certainly by the time of Confederation in Canada, well into the 50s. And there are still elements of the era of domination that still remain with us. You were saying that you had a talk on residential schools not too long ago. And so, this is part of that era of domination and assimilation, as well as dispossession from traditional homelands, being placed on reserves, various provisions in the Indian Act that attempted to assimilate First Nations people, and so many other things. In this period as well, we had the Canadian government often trying to deny that it had responsibility with respect to some Indigenous people, including Inuit and Métis, and then in some ways with respect to Indians, or what we call First Nations now, exercising a lot of control in some ways, but a lot of neglect in others. So a very dysfunctional relationship. And so you've gotten a little bit of a picture of that, and I don't intend to go through that whole history. I do recommend, if you guys ever, if we all get to actually kind of interact more, if you ever want to do a really interesting exercise, the blanket exercise that is offered by Kairos is a great way to be introduced to some of that history. But what I'm going to focus on for the rest of my talk is this fourth period that the Royal Commission talked about, the era of renewal and renegotiation, which they timed at being somewhere around the 50s to the present. But that's a lot of time. That's what, 70 years now, and counting. And there's been some, definitely some improvements over the previous era, but still some things left to be desired. So when I created this presentation, it was to sort of hit the milestones, the big milestones in the last 70 years that have signaled some change for Indigenous people in this country, but then also to say but there's still problems, and here's problems that remain with respect to this milestone. So I'm going to run through that presentation because I think it's helpful to understand the current relationship between Indigenous peoples and the Crown. And then in the second part of my presentation, I have a slideshow. I'll mention this, but you may know that in this past summer, the Government of Canada passed legislation to implement the UN Declaration on the Rights of Indigenous Peoples. And I wrote a paper this summer and shared it with, I haven't shared it with Jack? No, I've just shared the idea of it with you. I haven't actually let you see it yet. But I've been giving it a lot of thought, and I think that although it'll be a lot of work, in fact, the work on implementing the UN Declaration could do a lot to address the problems that I'm going to speak to that I think are still with us. So in the second part, I will review how I think that can change some things in important ways. But for now, I'm going to get into explaining to you these different milestones. So, they are amendments to the Indian Act that happened in 1951. The 1969 White Paper, not if you've heard of the White Paper. Okay, yeah, most people, good. The 1973 Calder decision, Section 35 of the Constitution Act, the 1992 Charlottetown Accord and the RCAP report are going to be the 6 milestones that I primarily speak about. Okay, so let's get started. So to start with the amendments to the Indian Act, the Indian Act was, well, there was a predecessor legislation to it, and yeah, feel free to ask me any questions at any point. Predecessor legislation, even slightly before Confederation, some of the provinces or some of the colonies had somewhat similar legislation, but the first act was passed in 1868, and it was called an Act for the Gradual Enfranchisement of Indians, which was all about assimilation. And then we get the actual Indian Act passed in 1876, and it's still in place today. It's undergone some amendments, but still in place today. And it's contained many of the policies. It creates reserves. It was, there was provisions in it that also provided for, various rules providing how the residential schools, allowing children to be taken to go to residential schools and other provisions. I'll speak to those. So, first of all, these amendments in 1951 were somewhat significant as representing, I think, a response to a bit of a change that happened after World War II. Of course, with the sort of global response, we get sort of the introduction of a bigger role for the UN, particularly with respect to human rights treaties and conventions and the UN Declaration on Human Rights. So we're seeing a greater concern for human rights across the board. And this starts to translate to Canada in terms of a recognition or concern for the well-being of First Nations people on reserve. It's sort of recognized at this point that Indigenous people, I think one more thing that I'll say is that post-World War II is when we get the sort of the real strong coming into being of the sort of Canada as the welfare state. By that I mean various programs and services, EI, the Canada Pension Plan, various other things coming into effect in the provinces, social assistance, child welfare, coming into effect, and recognizing that there has to be certain supports that are provided by the state for people's well-being. And at that point, or around this time, it starts to get noticed that First Nations people on reserve are not being provided the same types of services that other people are coming to expect now under these new types of programs. And the policy of the government of Canada before World War II, when it came to First Nations people living on reserves, was quite dire in some respects. Well, we had the residential school system, but on reserves, Indigenous peoples had been displaced. They weren't really able to exercise their traditional hunting and fishing modes of subsistence. Were essentially sort of forced not to really leave the boundaries of the reserve by and large. Because of that, their options in terms of how to make a livelihood were quite limited. There was no, pre-World War II, any sort of, what they had were Indian agents living on the reserve providing what were called sort of rations. And there's a great book, if you want to read it, by a fellow by the name of Hugh Shewell, and the title of it is Enough to Keep Them Alive. And that was the government's policy when it came to rations to Indians on reserve, was to just give them just enough to keep them alive, not to give them any more than that, and usually only to the most, the elderly and the most destitute, and anyone else should be, encouraged to pull themselves up by their own bootstrap, even though the sort of the impacts of colonialism were such that really there wasn't really many options. So the poverty in the communities was quite dire, and now with the advent of this social welfare system, it's starting to be noticed of the inequities that are existing in conditions on reserve. And so there's some pressure put on the federal government to look into this. So a committee is created who examines this, and kind of at the time, we sort of get a shift in assimilation sort of approaches. So prior to World War II, certainly the attitude of the federal government when it came to residential schools is take the Indian out of the child, and essentially that being Indigenous was something that was backwards and that somebody should be rid of. In post-World War II, it was still a desire for Indigenous people to become part of the mainstream, but less so based on sort of the more explicit, you're a lesser human being, but rather, don't you want to be part of us? So it's sort of 6 of one, half dozen of the other, but the idea being that the sort of best approach might be for Indigenous people to no longer be on reserve, to no longer have treaties, to no longer have the Indian Act, and simply just kind of be absorbed into the mainstream. So this thinking at the time was sort of couched in concepts of equality and citizenship. A concept of equality, however, that was, sort of the colorblind school of equality being that really formalistic, right? That, equality is treating everyone exactly the same, even if people have different needs and circumstances and deserve to be treated according to their needs and circumstances. So we get sort of an early version of equality, and the proposal is let's try to get the provinces to take over Indigenous services. Partly, I'm sure there was reasons of cost involved in this as well. So this was the recommendation of this committee. And they said, with all these services coming into effect, let's just see if they recommended that, the provinces take this over. And so Canada, Parliament, jumped on this when it was amending the Indian Act in 1951. And I'll explain that a bit more in a sec. I'll come to that. But in 1951, there was this massive overhaul of the Indian Act, and some of the earlier really egregious discriminatory pieces of policy that were in it were removed. Not all of them, but some of them. One being a ban on hiring lawyers. Did you know that from 1926 to 1951, there was a ban for Indigenous people to hire lawyers to represent them in land claims or any claims relating to the ban. So that was, in place for about 30 years. There was also provisions that criminalized different spiritual practices, and there were a number of provisions that impacted on, they were called enfranchisement provisions, which, enfranchisement means the vote. And the reason why they call them this is because under the law in Canada at the time, if you were an Indian under the Indian Act, you were not a citizen. And so, and those who, considered this issue